Calling case number 24056-11601. The people of the state of Michigan versus Denard Owens. Defendant is being charged with count 1, reckless driving causing death. Count 2, failure to stop at scene of accident when at fault resulting in death. Count 3, operating while intoxicated causing death. Count 4, reckless driving causing serious impairment. Count 5, operating while intoxicated, causing serious injury. Today's the date and time for our redetermination. Ms. Pearson, please.
Good morning, Your Honor. Lisa Coyle appearing on behalf of the people.
Good morning, Your Honor. Justice Shibe appearing on behalf of Mr. Owens.
Owens, state your name for the record.
Denard Owens.
Argument.
Your Honor, respectfully asking the court to consider a very high personal bond, GPS tether, house arrest, absolutely no driving, no drinking, no drugs, Your Honor. I don't believe he had capious history here. I understand these are very serious charges. Someone lost their life. These are allegations. He still is presumed innocent unless proven guilty beyond reasonable doubt. He has family ties and community ties. He lives with his parents. And again, I'm not aware of criminal history. I'm not aware that he's on probation or parole or anything pending or any priors. And he had just got hired, did not start the job yet. So he does not need to leave his house for any reason whatsoever. So respectfully asking the court to consider a very high personal bond with that GPS tether and house arrest and absolutely no driving.
Excuse me, Madam Clerk.
Yes, sir.
What are the other conditions besides the $250,000 cash bond? Are there any other conditions?
And Your Honor, I believe he was issued a tether as well at Arraignment.
Okay. All right. Court haven't heard the argument of counsel. Court finds that the $250,000 cash bond, excuse me. Court finds that the $250,000 cash bond is an unaffordable bond. In order to have an unaffordable bond, there has to be a showing that the defendant poses a danger to the community, the complaining witness, and/or is a flight risk. In this matter, the court finds that the $250,000 cash bond is an appropriate bond, that Mr. Owens, by clear and convincing standards, poses a danger to the community and a flight risk based on the allegation of leaving the scene of the crime. I'm not sure of all of the other conditions, but a GPS tether, house arrest, an alcohol tether also, and no non-prescribed drugs and no alcohol. And I'm sorry, did someone say something when I was talking? Who?
That was me, Your Honor. Now I understand. Thank you.
Okay. All right. Thank you.
You're all set, Mr. Owens.
I'm sorry.
Mr. Owens, you're all set. Could you,
Were you coming to say something to me?
get the debt?
Were you coming to me? Oh.
Thank you.
Coordinator.
Calling case number 24055-61501. The people of the state of Michigan versus James Purnell. Defendant is being charged with count one, first-degree home invasion. Count two, larceny from the person. Count three, domestic violence, second offense notice. Habitual offender, fourth offense notice. Today's the date and time for bond redetermination. Appearances, please.
Lisa Coyle appearing on behalf of the people. Good morning.
Morning.
Jessica Scheib on behalf of Mr. Purnell. Mr. Purnell, please state your full name for the record.
James Purnell.
All right, argument.
Your Honor, this is a matter from December 2023. It does have a little bit of age to it. I did have an opportunity to interview him myself last week before his arraignment. And it's my understanding that the day that he actually was brought into custody, which was on March 7th, the police came to his girlfriend's house. They asked him to come outside because they did not have a search warrant to come inside. He came outside immediately, talked to them, and that's when they brought him in. He was never arraigned on this matter before. I don't believe he's at flight risk. It's my understanding, Your Honor, that he has not seen the complaining witness since, except for one time when they went to a funeral together for his sister's mom. He said they don't talk, they're on good terms. She texts him, but he doesn't reply. He's moved on. He did used to live at this address. I'm not aware of anything assaultive pending. I know he has a pending possession of a drug case, Your Honor, or I believe he's on probation for that. And I believe his assaultive case was over 20 years ago in 2023. So I don't believe he's at flight risk or a danger. So I'm respectfully asking the court to consider a personal bond, no contact with the complaining witness. And since this is over 3 months with no incidents between him and the complaining witness that we are aware of, respectfully asking the court to consider that personal bond without a tether.
Madam Prosecutor.
Good morning, Your Honor. The people believe actually that the $500,000 bond set with the tether is inappropriate and should be actually higher in this matter. He has pending right now a felon in possession, felonious assault, felony firearm 2, domestic violence, same complaint that occurred on February 12th, 24. That arraignment was scheduled for the 9th, but it didn't go. He also has a pending home invasion first, witness intimidation, felonious assault, domestic violence second, MDP. That occurred allegedly on February 29th of 24. The same thing happened with that arraignment, didn't go. Same victim. Also, there was a warrant issued March 9th, 2020.
I'm sorry, Madam Prosecutor. What do you mean the arraignment didn't go? What does that mean?
I see it on the register of actions that it did not go. It was on the log list and it said that it did not go. So I don't know why it didn't. He wasn't arraigned on the warrant on those cases. But they are pending. But they are pending cases. They are, and he also has as of the 9th, there was a CSC 3, 2 counts, domestic violence second, habitual fourth, same victim issued on for an occurrence that occurred on allegedly February 4th of 24. He is currently on probation for a delivery less than 50. That is he's on probation till April 8th of 24. He also has an assaultive background. He's got a 2003, 5 counts of felonious assault, felon in possession, felony firearm, a 2002 domestic violence, as well as 2 non-assaultive priors, in addition to the one he's on probation. One's for an attempt delivery and in 2002 and a 2014 FIP. This case is extremely, I think the reason I'm bringing these cases up in the facts, because the facts are very important, because they all involve the same victim. This woman is going to wind up dead because of this man's actions. The court is not able to keep him away from her. And this occurred on the 3rd of December last year at about 4:30 a.m. The allegations that the complainant heard banging, she saw her lights and TV turn off. She sees the defendant entering through her den window. It says, "Bitch, I'm going to terrorize and make your life miserable." She calls 911. He jumps on her. He slaps her in the face and he says, "Bitch, don't ever call the police on me." He then took her phone and her car keys. Later that day, $500 was taken out of her account. I'm sorry, Your Honor. Just one moment.
Okay.
I apologize to the court. But anyhow, then he's got another case pending. Same victim. This occurs at 5:15 in the morning. He allegedly forces her door open. He enters her house. He observes he's in the bathroom. He turns the lights off. She runs to her bedroom. She tries to close the door. He said, "Bitch, you don't be running. If you come to court on me, I'm going to shoot you in the face." He then pushes her against the wall, allegedly, places a knife to her neck and told her, "Bitch, show up for court now." He then threw her phone to the ground and broke it. He then fled. She went to the second precinct immediately to report. On February 12th of this year at 1:30 in the morning, approximately, she's having a party at her house. He comes in uninvited and he states, "Y'all didn't invite me to the motherfucking party. Y'all better get out of here before I air this place out." And I think we all know that means shoot it up. He had a gun in his waistband. She runs outside. There's a witness in the bathroom who then calls 911. He comes back to the home and he's in her driveway pointing the gun at her. And finally, the allegations on February 4th is that the defendant came out of a closet in her house and said, "Bitch, you think about to sneak out of here." He grabs her by her hair, pulling the weave off of her head. He hits her in the head. He tries to pull her pants off. She fights back. She hides behind a bathroom door. He places his hand over his mouth and he digitally penetrated her. She got away from him and then he caught her again. He pulls her pants off and then he vaginally penetrated her.
Madam Prosecutor, I appreciate the context. I don't want to go too far into those allegations because I'm going to assume whatever's going on with the arraignment process, that those will come back in front of us. So I have context. Court haven't heard the arguments of counsel. Court finds that the $500,000 cash bond is an unaffordable bond. In order to have an unaffordable bond, there has to have a showing that the defendant poses a danger to the community, a danger to the complaining witness, and or is a flight risk. In this, the allegations and numerous allegations denote that the defendant poses a danger to the complaining witness. And based on that, the high cash bond is appropriate. The court is going to continue the bond as set by the magistrate. Thank you.
Thank you.
You're all set, Mr. Burnett. Can you get the deputy for me?
Yeah,
Can you get the officer for me?
yes.
Thank you. Attorney Keller?
Yes?
Ma'am,
Oh,
Hi, you were here on Owens?
that is correct, ma'am.
Okay, his bond was continued.
Okay, thank you very much. I appreciate that.
You're welcome. Good morning, Sheriff. Can I get Mr. Beard, Jacoby Beard?
Yes.
Next. Okay, cool. Thank you. State your name, sir.
My name is Jacoby Dewan Beard.
That's correct. I reached out also this morning to the complaining witness.
Calling case number 2405607-501. The people of the state of Michigan versus Jacoby Dewan Beard. Defendant is being charged with counts 1 through 3, assault with intent to murder. Counts
Okay.
4, 5, 6, 7, 8, 9. Assault with a dangerous weapon, felonious assault. Count 10, 11, 12, 13, 14, 15, 16, 17, and 18, weapons, felony firearm. Today's the date and time for bond redetermination. Appearances, please.
Good morning, Lisa Coyle, appearing on behalf of the people.
Hey, good morning, Your Honor. David Cripps, P34972, appearing on behalf of Mr. Jacoby Beard, who has joined us from Zoom from the Wayne County Jail.
State your name for the record.
Yes.
Me?
We're ready. I'm ready.
Mr. Beard, state your
Oh,
name.
Jacoby Beard. I apologize.
Okay, no, you're fine. Argument.
Judge, the bond is $500,000, 10%, which the defense argues is unaffordable for Mr. Beard. What the court needs to know right away is this is a reissuance. My client was originally arraigned on February 11th, 2024. Exam set for March 4th, 2024. We appeared on the day set for exam. The people were unable to proceed. They weren't ready with their proofs, so it was dismissed. And then it was reissued.
Mr.
And I
Cripps, what
appeared
was the
before
original bond? What was the original bond before?
5 million, 10%, Your Honor. On this case, Judge, my client has a job with ATF Company full-time. He lives with his mother and sister. His mother's name is Nico Chandler, who may be in the courtroom. I know she was trying to come today. So, Judge, the biggest issue here is obviously he sat in jail for close to a month, and the people weren't ready to proceed. And then they reissued without notifying us and arrested him at his home. I would have voluntarily turned him in had I been notified. But we're asking for we know the charges are serious, but we're asking for a reduction in bond. Thank you.
You're welcome. Madam Prosecutor.
Yes, Your Honor, good morning. And good morning to Mr. Cripps. I note that the defendant has in his record, the only thing that I see is a 2022 CCW completed under HIDA. The facts and the allegations in this case are very serious, Your Honor. He is alleged to have shot 4 people. And this is occurring back in July of 23, about 2:30 a.m., in which multiple cars were doing donuts and the defendant was firing shots. But in this sense, Your Honor, the proofs are very strong as to the identity of the shooter in this matter, because basically Mr. Beard gave it up himself, that the police did some good police work and they traced an Instagram account in which they got a video off of, and it shows the black Jeep Cherokee pulling into the lot. Individual gets out. He does a U-turn on Hubble. Multiple flashes or shots are coming from the driver's side, and the crowd disperses. As you know, 4 people are shot. And in this Instagram account that belongs to allegedly a Mr. Ferone Thomas, the defendant mentions he's involved in the shooting. He claims he shot 4 people in several cars. He said he had 42 in the clip, and after shooting only had 4 rounds left. He also attached a video of the shooting. In the video, there's audio, and you can hear over 30 rounds fired. You can see the Hubble Street sign in the video, giving credibility that he's there and this is what's occurring in real time. The officers then see that in November of 23, his Instagram account name changed and a new account profile is pictured, and that's the defendant's picture on that profile. They get a search warrant for the defendant's Instagram account in December. And he's had this account since February of 2019, and he's had 4 previous usernames. They also look into Mr. Thomas's account, and that they find that Beard shares his info of the 17-second video where the shots are heard, and that message thread by the defendant say, "That's me by myself," indicating the shooter. In the conversation, he said himself, like I said, he had 42 in and he had 4 left. He stated that he blacked out, meaning that he lost control. When asked who did he mean to shoot at, he responded, "I didn't give a bro a chance to blow the glitch. Not allow anyone else to fire a weapon." And then he writes, "I popped 4 people and shot so many cars up." And then he writes, "I can't be fucked with." So, Your Honor, then they follow up in August of 23. They find that he's looking on his Instagram to trade his Draco firearm for a Glock and $300. A Draco fires a 7.62 round, in which 29 of that caliber was recovered from that
Madam
scene.
Prosecutor, I hate to cut you off, but I have enough on this record to make a decision at this point.
I appreciate that. Thank you.
No, court haven't heard the arguments of counsel. Court finds that the 500,000 10% bond is an unaffordable bond. In order to have an unaffordable bond, there has to be a showing by clear and convincing evidence that the defendant poses a danger to the community, complaining witness, and or is a flight risk. In this matter, the court finds by clear and convincing evidence that the defendant poses a danger to the community. The actions that are alleged here are very dangerous and reckless, and a lot of people could have been killed. The bond is significantly lower than it was. I'm assuming the magistrate lowered the bond based on this being a reissue, and there may not be a high likelihood of conviction. With that being said, the court is going to continue the bond as set by the magistrate. Thank you.
Judge, one last issue.
Yes.
This case was dismissed by Judge Ronald Giles, and right now it's assigned to the docket of Judge Jefferson, pursuant to the rules of the court. That will be corrected. Thank you, Mr. Cripps, for putting that on the record. We will administratively make sure that's moved. Have a great day, Judge.
You also.
Thank you, everyone.
Marcia, make a note of that. And,
So, I have a question if I could.
Yeah.
So what does that mean?
Lindsay Board going to be?
Since your original case was in front of Judge Giles, the reissued case has to go back in front of Judge Giles, who dismissed the previous case. It cannot go to a new judge.
Okay.
Okay. All right. Thank you.
Thank you, Honor.
All right.
Oh.